Kaiyuan to brief us on the topic of the national level adjudication mechanism for intellectual property appeals, and she will also take your questions. With us today, we will also have the IPR Court's Vice President, Mr. He Zhongling, from the Supreme People's Court, and also Mr. Zhou Xiang from the IP Court of the Supreme People's Court. First, I would like to give the floor to Ms. Tao Kaiyuan. Ladies and gentlemen, friends from the media, Happy New Year. First of all, I would like to thank you for your support, for the attention and concern of the work of the Supreme People's Court. Setting up the national level IP court and establish the national level adjudication mechanism for intellectual property appeals is under the guidance of Xi Jinping's thought on socialism with Chinese characteristics for the new era, and also bear in mind the overall interests of the party and the country. Since the establishment of the IP Court, we have been guided by Xi Jinping's thought on socialism with Chinese characteristics for the new era, as well as the Xi Jinping thought on rule of law, and abide by the spirit of the 19th and the 20th Party Congress. And also, we are making solid efforts in our course of the work. By December the 31st, 2021, and we have handled over 90,000 cases and also concluded over 50,000 cases. For all of the work has been improved before the reform. This also shows that at the national level, the adjudication mechanism has shown advantages in handling the intellectual property cases and also improved the efficiency of the case hearing. And also we have pulled all of the cases into one judicial body. So for the IP Court, we would like to stay committed to protect the innovation, especially targeting key areas, emerging areas, and provide legal support to protect the innovation-driven development. We will also issue more penalties for the infringement of the IPR in 2018, and we initiate the punitive penalty for the infringement of the IP. Second, we have ensured a fair market to establish a unified market. For the IP Court, we have done a lot of work to protect the IPR. We also do our best to fight against the monopoly and also to fight against the unfair competition. And also we have established the interpretation on the anti-monopoly, which will be released soon. And also we will try our best to provide legal support for the technical secrets and the monopoly and also the computer software. Second, we will continue to serve the high-level opening up. For the court, will continue to protect the interests of domestic and overseas enterprises, and we have handled overseas cases of over 1,800 cases. And also we are trying our best to forge the mediation, and we are trying to settle the cross-border disputes and to provide support in the global governance of the intellectual property rights. Fourth, we will continue to deepen the reform and opening up and continue to improve the level of the adjudication mechanism. For the IP Court, we will also issue guidance to the judges to make sure that for all the standards are unified. And we have to work for all the cases related to different types of nature, and also we will form a sharing platform and establish a big data center. And we are trying our best to open up the online platform to handle all of these cases. For the pilot area of the IP court has also passed the third-party examination, and also this examination has been passed by the Standing Committee of the National People's Congress. And also for all of these, pilot court has already passed the test. First of all, we have unified all of the standards of the judges, especially where we pay attention to the anti-monopoly and also the anti-unfair competition issues. And we have also alleviate the burden for the litigants for their concerns about local protection. And also we are seeing that for the case withdrawal rate has been largely reduced. And also we are seeing that for the retrial rate has also largely reduced. And for this rate has reduced to 0.5%. So for all of these figures, they are much better than the figure before the reform. Third, for the judicial credibility and also the global impact has been significantly improved. For China has handled a great number of overseas handling, and also we have a great number of expertise to handle all of the IP cases. For many overseas companies, they would like to come to China to settle all of the disputes for the intellectual property. China is the top destination for handle all of these cases. Fourth, we have provided our legal support to promote innovation-driven development and ensure China to build itself into a nation in science and technology. And also we have handled cases of above 30% of IP cases concerning the emerging industries. We are trying our best to improve the core competitiveness of the enterprises in China. In the past 5 years, this has shown that for the decision to establish the IP court is correct. However, this is still an emergent court. Right now, we still have a lot of room for improvement of the IP court. We will continue to deepen our reform of the IP court and continue to improve the reform for the national level adjudication mechanism for the IP appeals. And also we would like to improve the modernization of the adjudication mechanism so as to serve the Chinese modernization. So that is the briefing for the past 5 years in our work. In order to provide better services to the public, we also have selected 10 typical cases, and also we will release all of these cases today. And in the upcoming days, we will continue to organize conferences to release work reports in 2023 and also the guidance for the judges so that we can explain our work to the public and receive suggestions from the public. So that is my introduction. Right now, we would like to take your questions. Thank you. Thank you, Madam Ms. Tao. So now the floor is open for questions. Thank you. With CMG. So for the IP court has established for 5 years. And we also see good progress in the national level adjudication mechanism for IP appeals. So right now, for the IP court, it's a very important part in China. What is the upcoming steps for our work? I would like to take your question. First of all, thank you for your question. Thank you for your concern for the future development of the IP court. I believe this is a question concerning all the society. As I just mentioned, in the past 5 years, we have continued to explore the reform of the adjudication mechanism, and also we have made a lot of progress. In the past 5 years, it has shown that the decision from the CPC Central Committee is correct. And in the future, we will continue our reform in the following aspects. Right now, we have to consider the current situation of the operation of the IP court, and also we have to consider the current situation. I think we have to focus on two aspects. First, we have to improve the national level adjudication mechanism for the intellectual property appeals. We have always talking about one word, that is the national level adjudication mechanism for IP appeals. It sounds complicated, but now it is because right now it is just a mechanism. We have not yet come to a point to an agency or an institute. So first of all, we have to collect our experiences. So first of all, we have to refer to the guidance that we have released in the past, covering 2021 to 2025. First, we have to pay attention to the wording of their guidelines, because the ultimate goal for us is to establish a national level adjudication institute. And when we are establishing the top level design, and we are able to establish an institute to handle all of the anti-monopoly cases and other technology-related cases. So in the past, we emphasized that we will have 3 years of pilot time, and then we will have the examination. So we will work with the Law Academy and also the CAST in China, and also we will have a standing committee of the MPC to evaluate our work. So first, during this process, for all of these 3 agencies and institutes, they have asked the same questions. So right now, we are able to establish a IP court at a national level in China. And I believe this is an ideal plan at this stage. This is the ultimate goal we are marching towards to, and this will serve the innovation-driven development in China, and also to ensure a self-reliance in science and technology in China, so as to promote the high-level development and high-quality development in China. So the first step, we have to build up consensus across the board. And the second, we have to provide support in all aspects to support the establishment of the IP court. This covers a number of different sectors. At this stage, we will try our best to select talents to support the IP court. So that means we will recruit talents for the IP case hearings, and these people will be working in the court in the future. And this is a very important task for the SPC's IP court. By having all the talents, we can make sure that the adjudication system can move forward. Maybe you don't have the chance to pay a visit to the IP court. If you are interested, we welcome you to pay a visit to the SPC's IP court. Because right now, we are still under poor condition. And for everyone, if they had ever visited the IP court, they will be deeply touched by the hard work by our staff. In the end, for the reform of the IP court, we'll continue to take advantage or leverage the role of the national level adjudication mechanism for the IP appeals and serve the nation. Thank you. Next question, please. Thank you. Last year, the Supreme People's Court has released a number of cases regarding the IP protection for the SMEs. My question is, for the IP court, what are some of the work have been done by the court to protect the private sectors? Thank you. I would like to answer your questions. First of all, thank you for your question. So for the private enterprises, they have played a key role in promoting innovation and development. So one of the key features for our IP courts, we will serve a great number of private enterprises. Since the establishment of the IP courts, we will stay committed to the two unshakable guidance from the 20th Party Congress. We will try our best to protect the legitimate rights of the private enterprises. I would like to brief you in 4 aspects. First, I would like to pay equal attention to all the market entities. For our IP court, no matter whether you are the SOEs, foreign invested companies, private companies, big or small in size, and we will pay equal attention and also handle the cases equally for all of these cases. And for today's cases we are going to release, actually we will evaluate all of these cases equally. For example, for one of the cases, this concerns one joint venture and also one private enterprises. So for one party involved is a party from an SOE, and the second party involved in the private enterprises. And we are also supporting the private enterprises, and also we are issuing the punitive penalty of over 280 million yuan. So during the law enforcement, we have made sure that the mediation has been met between the two parties. And for the litigant, it has received over 60 trillion yuan, and this has set a record for the settlement of the case. And also, we are going to release a second case. This is regarding the rubber. So for one of the party involved is from an SOE, and also the other party is also from a private enterprises. So for the IP court, we also issue a punitive penalty to the litigant to pay over 200 million yuan to the party that has been suffered. And also, we have made a very equal and fair judgment to the settlement of the case. And the second, we will continue to provide the legal support for the innovation-driven development to protect the legitimate rights of the private enterprises. For example, we will pay attention to the patent protection. So also, this time for the case is also involving the dispute between a private enterprises and a transnational enterprises. And in the end, the transnational enterprises also have to pay the punitive penalty to the private enterprises. And also, for the third area, we will continue to ensure a level playing field in the market. And today, for all the cases we are releasing, 2 of them are about the anti-monopoly cases. And for all of these cases, they also have the similar features, because for the litigant, they are small enterprises. And in the end, we are supporting the small enterprises. And also, these companies are able to receive the penalties and the compensations. And also, we handle a number of the unfair competition cases. For the unfair competition cases, these two companies, they are private companies, and for one of the company, they are not follow the market rule. And also, we are issuing a penalty of 50 million to one private enterprises to pay the other. So we will do our utmost efforts to ensure a fair market. Fourth, we will try our best to boost the win-win cooperation. So we would like to convert the confrontation between the two parties to mediation or potential cooperation. So since the inception of the IP court in the past 5 years, I have said that the withdrawal rate of the second instances has been reached the figure of 50%. And today, during our release of the case, so one of the cases is regarded a smart robot or AI robot. So for these two enterprises, they're also high-tech companies. For these two companies, they also have the patents of over 2,000 at their hands. So one company is from Beijing and the other one is from Shenzhen. For these two companies, they have sent several cases to the IP court. And as far as we know, within 1 month, the two sides have reached reconciliation. And also, all the 11 cases have been resolved. So for the two sides, they also pay their gratitude to the IP court. Because I would say for these two companies, they are innovative companies, and we are trying our best to promote the win-win cooperation between these companies. So for the IP court, we will continue to improve our systems and also to provide a good environment for the private enterprises. And in tomorrow morning, we will continue to host a press conference to hear the suggestions from the market entities. Especially, we would like to hear the suggestions from the deputies from those private enterprises. Thank you. Next question, please. With people.net, not long ago, for the IP court, it has hearing cases regarding the technical secrets, and also this involve a huge amount of compensation. My question is, what work have been done from the IP court to protect the IP rights concerning the technical secrets? Thank you. Thank you for your question. For the IP court, since its exception, we will continue to step up efforts to protect the legal rights for the enterprises, especially concerning the infringement of the IPR. And this year, for the IP court has issued a penalty above 100 million yuan. I would like to give you an explanation in 4 aspects. First, we would like to set up a very strict standard to emphasize the judicial credibility. We found that for some of the plaintiffs, they have invested a great amount of money, and also they have gained the technological edge in the market. As you said, for the plaintiff, it is the largest supplier, and also it takes up 20% of the global share. So for the IP infringement, we have to ensure that we issue a huge amount of the penalty to the defendant. And the second, we are trying our best to find out the loss of the plaintiff because of the infringement of the IP, so as to give an appropriate figure of the penalty to the other side. And for the case we just mentioned, for the first instance, it issued the amount of 130 million yuan as the penalty. For the second instance, we continue to dip into the figure, and we found that for the defendant, it also have gained a great amount of profit because of the infringement of the IP. So in the end, for the IP courts, we had increased the amount of the compensation and the penalty. Third, we have to uphold justice. For the IP court, we have to pay attention to the amount of the compensation, because first of all, we have to evaluate the situation to set up the appropriate amount of the compensation. For the case you mentioned, for the first instance, it gave the penalty of 350 million yuan, and during the second instance, considering all the relevant factors, in the end, it identified that 159 million RMB shall be issued to the plaintiff. With our analysis and examination, especially for issues related to the infringement of the IPR, we will also give sentences to the defendant. And also for some of the companies, they are transferring their share to other parts, and they are trying their best to avoid the penalty. In this case, the IP court will uphold its judgment, and also to make sure that for all of these judgments will be released and also be implemented fairly. Fourth, we will implement the punitive compensation. So for the court, we will continue to abide by the civil code, and also we have to look into the law on the anti-unfair competition law. By issuing all of these punitive compensations so as to make sure that all of these cases can be handled properly, especially for the cases related to technical secrets, we will double or even give a huger amount of the penalties to the accuser. And going next, our court will continue to follow our guidance. For each one of the cases, we will look into the facts, and we will make use of all these punitive compensations and the penalties, and also to accurately calculate the amount to make sure that the amount can also serve the private enterprises. With Xinhua News Agency, so right now we are seeing that we have more innovation coming up in the society. What are some of the key issues in the society, and how the Supreme People's Court handle all of this situation? Thank you. I would like to take your question. So for the IP, it is very important to protect the innovation, especially right now in China. You could see big advancement in science and technology. And right now in the IP protection, we are seeing some of the new features. I would like to analyze in 4 aspects. First, if we look at the number of cases, we have handled more cases, and also we are setting out more stricter standards for the IP court. In the past 5 years, actually we could see we have a 27% surge in the IP cases involving technology and monopoly. And especially for the IP cases related to the invention patents, this will account for 39%, and also we are issuing more sentences and penalties. And this, we are seeing that we need the IP court to protect the innovation-driven development in China. Second, I also want to emphasize the IP cases involving the emerging industries. And we are seeing a lot of disputes about the IP cases about the emerging industries. So we can see all of these changes in these figures. In 2021, we only have like 1/4 for the cases involving emerging industries. But last year, we are seeing that these cases has accounted 1/3 of all the IP cases infringements. So now we are seeing that this has been the future trend, and also this will give more challenges for our rules for the IP court in our adjudication. Third, and also we are seeing a lot of overseas cases regarding the IPR infringement. So for the IP court, we have handled overseas cases of about 1/10 of the total cases, especially relating to the invention patents. And for some of the cases, it involves not only overseas enterprises, but also involves the domestic companies. And all of these are very important for us because all of these cases are related to the core technologies and key areas in China. And in the past 5 years, we have handled over 7,000 cases from 6 provinces, from Beijing, Guangdong province, Zhejiang, Jiangsu, and the Shandong provinces. For these 6 provinces, it takes about like 60% of the overall cases. And also we are seeing some of the cases coming from the western side of China. And we are handling more cases. For example, I just talked about the AI robot. And for this case, also coming to the SPC's IP court. In facing all of these new challenges, once again, I'd like to emphasize that. So first, we are seeing an increase of the IP cases, and also all of these cases are technical in nature. And in the future, and we will continue to follow the guidance from the previous conferences we have been organized. So first, we have to abide by our judicial standards, and also we have to unify our standards in the case handling. And second, we have to improve the adjudication mechanism. So first, we have to deepen our reform of the national level adjudication mechanism for the IP appeals. And the second, we have to improve the functionalities for local adjudication systems. And third, we will continue our efforts to establish a procedure act for the IP appeals, especially for guidance targeting the IP cases. Fourth, we will continue to improve the level, the efficiency of the adjudication process. This means that we have to establish a professional team to handle all of these cases. Thank you. Next question, please. With Legal Daily, my question is, so for some of the false litigation, what will be some of the negative impacts? What will be the work done by the SPCs to facilitate the high-level development and innovation-driven development in China? Thank you. I would like to take your questions. You are mentioning the credibility, and this is also a core value for China's value. So credibility is a very important part for our work. So for the false litigation, we don't see much in the IP courts, but in the past few years, we are seeing a lot of vicious litigation. So for the national court, we are receiving 152 cases in 2023 about the vicious litigation, which has been increased by 50% compared to 2022. For the vicious litigation, for some of these litigants, they are trying to get compensation from this litigation. So for the patent-related cases, I have seen some features. So for some of the litigants, if they think, sometimes they're saying that they can still to file litigation about their patent right, even though their patent right has been expired. That is the first scenario. And the second, they will try to steal the idea of other parties and also to register patent and to file the litigation against the other. And third, in some scenarios, the patent right infringement is not exist, but for some of the litigants, they continue to file the litigation and attempt to receive the compensation. So these are the several scenarios. For the vicious litigation regarding the patent right, this also will damage the credibility. So for all of these illegal litigation, this will also affect the value of the share, and also it will cause consequences for the other part. For example, the other party may not able to launch new products, and they have to pay huge amount of expenses for the litigation. And also, for some of the litigants, their legitimate rights will be damaged because of the litigation. These are some of the negative impacts. And also, this will create a very negative influence in the market and also forge an unfair competition in the market. And this will also waste a number of the legal resources because of this illegal or unjustified litigation. In 2011, for the Supreme People's Court, we have made amendments for our regulation. Especially, we are targeting all of these vicious litigation. And also, we open up a channel for those victims to receive compensation from this unrightful litigation. So, for example, we have made sure that for all of these legitimate rights of the defendant and also the plaintiffs can be safeguarded. Last year, the SPC's IP court have evaluated 3 cases, especially for those people who have abusive use of their power. They have to take responsibilities for their vicious act. For example, in one of the cases, the IP court has gave the judgment of the vicious litigation. And also, we advocate the litigants do not use the law in an abusive manner. And in the future, the court will continue to pay attention to the false litigation and vicious litigation and carry forward the philosophy of credibility. We want to guide all the litigants to exercise their lawful rights so as to build a law-based society. Thank you. Next question, please. With Bohemian paper, in 2024, we have seen the #1 document issued by the central government. My question is, what will be the work have been done by the Supreme People's Court in terms of the IP protection in farming industry? I would like to take your question. So chips is always a popular word. Actually, the seeds is the chips in the farming industry. So it is very important for us to protect the IP rights in the farming industry. First, we will abide by certain standards to handle all of the cases relating to the new varieties of the plants. So in the past few years, we have handled cases with over 480 cases, and this has covered the major variety of the plants. For most of the cases, they have won the litigation and also receive appropriate punitive compensation. For many cases, they are relating to the new variety of plants. For example, in 2021, we had released the case 818 in Beijing and Tianjin. This is also a seed of the new variety of the plants. And at that time, we issued a penalty of 500 million yuan. And last year, we also received IP protection cases in the farming industry. And also for one individual, it also violated IP rights of the farming. And also, this individual have to pay the punitive compensation to the other side. And the second, we will continue to provide guidance to other intermediate courts. In 2021, we have released the Article 25 regarding the IP protection in farming, and this will help us to improve the IP protection of the new varieties of the plants. For some of the explanation we have been released will be guided the farming industry to protect their IP rights. And we have a lot of typical cases relating to the IP protection of the new varieties of the plants. And in March this year, we will continue to release the new cases regarding these plants. And third, we will continue to work with the administrative companies. And we are working with the China Association for Rural Development. And for this cooperation, it's very effective for us to protect the rights for the IP in the farming industry, and also we are seeking a lot of advices from the experts. We also roll out the ratification program. We are working with the Ministry of Agriculture and Rural Affairs to look into typical cases. And also we are providing trainings to the judicial staffs in the protection of the IP or of the IP in the farming industry. And each year we will attend the seed conferences that have been organized in Hainan province. We will continue to provide the judicial support in protecting the IP in the farming industry. So first, we will continue strengthen our work, especially emphasizing the punitive compensation. And the second, we will continue to work with the administrative departments. Third, we will implement the articles that has been stipulated in the law on seeds to make sure that all of these rules and regulations can be implemented. We will try to provide the legal support to promote the innovation-driven development in China. Next question, please. With CMG, we have noted that in the Standing Committee of the NPC, according to their suggestions and provisions, the first step is we are trying our best to unify our standards. So that is the basic for setting up the IP court. My question is, for the SPC, in what aspects have we unified the standards in the case handling and the settlement? I would like to take your questions. First, I would like to thank you for your question. So for the CPC Central Committee has made the decision, and also the decision has been passed by the Standing Committee of the NPC to establish the IP court. So the most important thing is to align all our standards. So in the past, we have 32 higher people's courts to handle the IP cases, but right now we have only one judicial body to look into all of these IP-related issues. So first, and also the most important thing is that we have to release a guideline to explain our work, and also we have to work together with the other intermediate courts. So for the judicial interpretation, back in 2021, we have released one version. At that time, we are drafting the explanation on our work in the anti-monopoly. And for this law, this will cover about like 50 articles and 50 sections. So we will explain what is the concept of the anti-monopoly and what is the role of the market and how we examine the anti-monopoly issues. So these are the big areas and the key sections for the law. And please stay tuned with us, and we will give you more details about this law. And the second, we are paying attention to the law enforcement. So for the Supreme People's Court, we have released over 200 cases, and for some typical cases, they are relating to the IP cases. So, for example, today we are releasing a case relating to the IP protection of the lithium battery. So this one is relating to the layout designs of integrated circuits. Because in this kind of the IP case, we don't have much of that kind of cases. So this time we are paying special attention to this case. For example, the registration procedures of the layout design of the integrated circuits. And also we have to identify what is the standard to protect the layout designs of the integrated circuits. So as I said, we released this guideline, and this will also have some legal effects to protect some of these intellectual property products in China. So for the Higher People's Court and also the Supreme People's Court, we will release a number of typical cases. So all of these cases may provide references for different courts to handle the IP-related cases. So for the Supreme People's Court, on a daily basis, we will release the judgment guidance. And tomorrow, we will release the judge guideline for 2023. And this will also involving 296 cases. So for all the judges, before they made a decision, they have to refer to all of these guidelines and the references. So by having all of this information and archives, and this will provide great significance for the court to make their final decisions. For example, in 2015, we once again identified the exact calculation of the punitive compensation. So for the judge, they have to look into all the evidences and also the actual facts, and then to come up with the appropriate figure of the punitive compensation. In the future, for the Supreme People's Court, we will pay attention to the intermediate People's Courts in their hearings of the IP cases. We are trying our best to provide more references and more typical cases, and we will continue to release more IP cases explanation. So for the SPCs, we will continue to release the typical cases for references. Thank you. Next question, please. With cover news. So sometimes we are seeing that it takes a long time for the IP infringement cases. So what work have been done by SPCs to improve the efficiency to handle all of these IPR infringement cases? For a long time, for the rights protection, indeed, it is a very difficult tribunal because it costs higher costs and also lasts for a really long time. And this concerns the people around the society. And this is also the priority for the SPC to do our work. In the previous questions, I actually touched upon on how to receive the punitive compensation on the IPR infringement issue. And now I would like to talk about how we solve the other issues in the legal rights protection. Sometimes it is very difficult to collect the evidence for some IP-related issues. So first, we will refer to some of the legal standards and trying our utmost efforts to reduce the difficulty for the litigant to collect the evidence. As I said, in one of the previous cases, for one party, they are very difficult to collect the evidence. For example, there is a dispute between the plaintiff and also the defendant. When necessary, we will ask the defendant to provide the evidence. If the defendant is not able to provide evidence to defend themselves, then the IP court will support the plaintiff. By taking that cases, we are seeing that we are able to protect the legitimate rights of the plaintiff. And the second, we will look into the application in collecting the evidence. For example, we will pass some of the application, approve some of the application of the litigant to conduct on-site investigation. And also, we will send out staff to accompany the litigant to do the on-site investigation. When the litigant collects sufficient evidence on site, and the court will also make legitimate decision and judgment. And also, there are people saying that there is a long hearing cycle. So actually, in the past 5 years, the average time is 182 days for the hearing cycle. And for the IP court, we have done a lot of work to shorten the hearing cycle. So first, we will look into the case to see if we can change the original sentence. For example, if some of the cases have passed the first instance, and then we will examine the cases of the second instances. And this will shorten the time. We will avoid the reopening of the cases. In the past 5 years, we are seeing that the change of the original sentence has been reached 0.5%. That has been largely reduced compared to the figure before the reform. And also, we are trying our best to make sure that all of the cases of the second instance can be carefully examined when it has been sent to the SPC's IP court. And we have well noted that for the hearing cycle, it's very long for certain IP settlement issues. For those complex issues, we will work with the litigants. For example, for some of the patent-related issues, we will work with both parties to find out a solution. If the patent cannot be justified by the courts, we will issue commitment letters to the two litigants, and also we will make the relevant judicial adjudication. By issuing the commitment letter, this will also improve the efficiency of the adjudication. And the third, we will try our best to improve the correlation between the first instance and the second instance. So in the past 5 years, the average hearing time for the second instance is within 1 month. And also, we require the first instance to upload the electronic files. Fourth, we will try our best to make use of the technology to handle all of these cases. In the past 5 years, we have handled over 9,000 cases online, and this is all well received by the litigants. And also, for all of these online litigation, also have a higher rate of the settlement rate. So by having all of these different methods, we will help us to improve the efficiency, but still we have a long way to go in improving the efficiency of the case hearing. And right now we have restricted resources to handle all of these cases. And in the future, for the IP courts, we will continue to optimize our structures and also to provide legal support for the innovation-driven development. 2 last questions, please. Thank you. With Guangming paper. So for the IP court, my question is, what will be some of the typical cases in boosting the innovation-driven development in China? And what are some of the best practices of the IP court? Thank you. Thank you for your question. As I just mentioned that the reason why we are setting up the IP court is to create a good environment to promote the innovation-driven development. So we have just talked about the most important thing for us is to protect the legitimate rights of the litigants, and also it will help us to promote the scientific and the technological innovation in China. So in the past few years, the IP court has initiated 8 major steps. So today I would like to elaborate on 5 key areas. First, we will try our best to protect the legitimate rights of the litigants. First, we will strengthen the intellectual property, and also we will protect the rights of the litigants. So I just mentioned one of the cases relating to the royalties and also the IPs. And for some of the cases, they are relating to the patent invention. So we have to pay attention to the protection methods for this kind of patents, because if we follow the previous methods, it is difficult to protect the rights for the patents for inventions. But this time, we are taking a number of portfolio methods to protect the patents. So this is one aspect. And second, we need to beef up our efforts in protecting the intellectual property. So as my colleague has just said, we will continue to increase the punitive compensation. So maybe when you look at our typical cases, you could get the essence on how to protect the IP rights. And third, we have to establish an effective channel or mechanism to protect the IP infringement issues. So first, we will try to explore the facts to make sure that all of the measures can be implemented. For example, in some cases, we will give the exact guidance or the exact instructions to the litigants. For example, we will set up a specific timeline for the 2 litigants. So we have just mentioned that for one of the cases, the punitive compensation has reached 680 million yuan. So that means that for one of the litigants, they have paid special attention to this judgment because the amount is very high if they violate the rules. And third, I want to talk about one of the cases related to the automobile, one of the invention patents IP violation. So in China, we have many procedures for the IP case. For example, we have the first instance and also we have the second instance. If the litigants they are not satisfied with the results or judgments for a civil or administrative case that is technical in nature, and this person or this enterprise can file an appeal with the Supreme People's Court. And by doing that, the SPC can make decisive decisions to make sure that the rights can be protected by the litigant. And fourth, we have just talked about the long hearing cycle. So in the future, we will continue to improve the efficiency of the case hearing. And fifth, so we will prioritize certain areas for the IP protection. For example, for some of the cutting-edge technologies. And also, we have to pay a lot of attention to the emerging industries and the key technologies. And we will give priority to all of the IP cases involving these aspects. So, for example, for the IP cases relating to the pharmaceuticals, so we will organize the expertise to discuss these IP issues and IP cases. Some of the cases are quite sensitive, so we have to make sure that the legitimate rights of the litigants can be protected through the work of SPC's IP court. So, going next, we will continue to abide by our philosophy to protect the IP cases, to make sure that we can protect the legitimate rights of the litigants, and also to make sure that the role of the IP courts at national level can be implemented. Thank you. Next question, please. We have known that for the SPC's IP court has received a lot of international attention from the world. My question is, what is the progress made by the IP court in handling the overseas cases? So what is the role for the court to improve China's global influence? Thank you for your question, and thank you for your attention to SPC's IP court's handling of the overseas cases. So for the IP court, one of our highlights is to handle the overseas IP cases. So just now, Mr. He has responded to some of the areas touching upon the overseas IP cases. So I would like to elaborate on that. If we look at some of our figures, by the end of last year, we have handled 1,678 overseas cases, and right now over 1,100 cases have been closed. So meaning that for all of these overseas cases has accounted 1/10 of the overall IP cases received in the IP court. Meaning that for the IP court is global in nature. And the second, we are also handle a lot of IP cases relating to the patents for inventions. And for the overseas cases accounted for about 1/3. put it in a simple way, for some of the overseas litigants, they would like to apply for patents in China. So that's why they may file litigation or cases related to their patents in China. And also for some of the overseas enterprises, they would like to come to China to resolve some of their IP disputes and the IP cases, and meaning that China has become one of their favorite places in resolving some of their IP concerns and issues. And for some of the cases, they may have some relations of the overseas enterprises. This shows that the IP protection is very important for the global governance. For example, especially in the area of the pharmaceuticals, we see a lot of the IP cases in this regard, meaning that for some companies, they file the litigation in China and also they file the litigation in other countries. I think this is also very important for us to handle those cases properly. So for the protection of the IP has long time been a heated topic in the world. So for China's IP protection, we will continue to promote the innovation-driven development, and also we are trying our best to provide a facilitating environment and cater the needs for the overseas enterprises. As we just talked about for the private enterprises, no matter it is a SMEs or an SOEs, so we will treat all of these enterprises equally. So that is the same for us to handle all of the cases regarding the overseas IP cases. So we have to do our best to solve all of those issues relating to the overseas companies. So I would like to cite one example, that is the DAKS case. This is about a IP issue relating to the technical secrets. We also received a thank you letter from the overseas company, and they're saying that China has handled the IP cases in a fair manner. And also we receive a lot of overseas letters, and also they speak highly about China's positioning in handling the IP cases. And this will also boost the confidence for the foreign investments. And we have a lot of successful cases in handling the overseas IP cases. So for these disputes, some of the cases, they're relating to the overseas companies, and sometimes we are seeing some of the cases involving overseas companies as well as the Chinese companies. And also we are hearing a lot of touching stories. So right now, for the IP court has established for 5 years, and also Ripple have sent us a letter to speak highly about our achievements in the past 5 years. Today's afternoon, we will also release a promo. So in that promo, which lasts for about 10 minutes, we will show our achievements in the past 5 years. And this year, according to our plan, we will work with Ripple and also organize a seminar in the city of Hangzhou, and we will be welcoming experts and baristas from United States and European countries. We will try to forge cooperation with them. And also, when necessary, we will go back to the United States and the European countries to discuss issues about the IP-related cases. I would like to say that for the developed countries, they are also paying a lot of attention to the IP protection, and also they acknowledge our achievement that have been made in the past 5 years. The IP court pay great attention to the IP cases related overseas settlements. So we will treat all the enterprises in an equally manner to make sure that all the investments are safe from these overseas enterprises. And the second, we will act in a transparent way to improve the sense of gaining of those companies. Third, we will try our best to improve the adjudication process to show the responsibility of China, and also we would like to contribute the Chinese wisdom to the world. Thank you. Thank you all the speakers. Thank you for your participation. That's the end of today's press conference.